Hello. For the module this week, we are going to continue exploring the wacky world of torts. And so we are looking this week at three kinds of torts. And we had said last time that there's three categories of torts. Remember, a tort is an injury to person or property. And there's all kinds of injuries you could have. You could have mental, you could have physical injuries. They usually have some sort of manifestation in a physical injury so that it'll be simply for evidence easier to prove. And in any case, we are looking at who is the one who committed this tort, which we also can call a tortfeasor in a good old fashioned way. And that would then be the person who is the defendant in the lawsuit because it's a civil lawsuit for money damages to compensate the victim for the harm, for the injury. And when we look at this in three categories, we have intentional torts, we have negligence torts, and then the third category is strict liability torts. And as I said last video, the purpose really kind of defines how we get into the definition. So for intentional torts, we're more likely to have those kinds of more severe damages. I say more likely, but we don't know if there'll be punitive damages, depends on the facts. But it certainly is always going to be a compensation element involved here when we talk about damages. And you might say, why is she talking about damages at the beginning? Because at the beginning of every lawsuit, you stop and you think, if you're the plaintiff, what do I want at the end of this lawsuit? And that frames the kind of tort that this may be categorized as, because we're talking about a fact pattern. Something happened to this person, and you think, well, is it a tort? Is this something that you could sue for the injury? And then have the compensation. What kind of tort would it be? And what kind of compensation would I receive at the end of this case? You're thinking about that at the beginning of this case. And clearly nowadays, especially in our country, we talked about litigation in this class. In this country, you're more likely to be already thinking right after the injury occurs and gathering your evidence, preserving the record, your facts, whether it's a police report or other kinds of evidence, your medical bills, because you're already, if you're the victim, certainly, and if you're the lawyer for the victim, you're already thinking about the plaintiff that this person will become in a civil way. So when we look at the torts that are in this module, you're going to see we'll talk about intellectual property. And intellectual property is a kind of an intentional tort because there, the injury is that the person or their good name of their company has somehow been injured. And it also could be what you might, in colloquial terms, call a theft of the person's property. That's an injury. And the property, when it's intellectual property, might be their ideas. So, in a colloquial way, you might say, oh, somebody stole my idea. But we're going to reframe that into torts language and say, because it's a civil lawsuit, not a crime, right? And we'll say, well, this is something where the person misappropriated my, whatever it is, trade secret, trademark. They infringed my patent. See, the language changes because it's civil. It could be that it is copyright infringement. Somebody copied my work and then reproduced it as their own. That would be copyright infringement, whether that work is something written or something musical. There's all different forms of copyright, and there's different forms of patents as well, trade secret, and even trademark, because trademark could be a brand name, could be a slogan, a company logo. It could be something that's physical in the sense that it's a design that's a combination of things like it could be the Nike swoosh, it could be the packaging of a Pepsi can. And those are things that are ideas that belong to someone, an individual or a company, that you could then sue for money damages for the misappropriation or the infringement of that. Those are parts of intentional torts. There's other kinds of intentional torts too. And then a whole long list of them that the facts might fit into. A lot of those are business torts, like the ones I just described. It could even be something like somebody harms your good name, your character. Defamation is another business tort or individual that is for an intentional harm that somebody does. And those are a broad category. As I said, you look at your facts and you figure out it's like a smorgasbord of a buffet, really, of, okay, here's column A, column B. These are the way that these facts fit in place, and it together looks like the tort of, and then we have a list of torts. It could be assault, battery. These are intentional torts. It could be, and you're going to, of course, read about them. It could be something like, trying to think of a bunch of them, imprisonment. That is not real prison, but it's happening in a store context where somebody is not being allowed to leave because they're looking through the bag in the security department. They think that this was shoplifting. Well, that could be a tort because you are restrained. So all these facts can lead to a potential tort that are in the intentional tort category. Okay, so we talked about many of those in the module last week. This week, we're looking specifically at the intellectual property, the IP kinds of torts that especially you people in marketing might be aware of and be aware of, right? Because you want to be very careful in the statements you make about a competitor's product or even your own in way of preserving your property rights so that you're then laying the foundation if someone were to then take or copy your design, your idea, or your brand name. So those are all things that are in the IP category. The second category of torts that we're going to focus on this week, negligence. And we mentioned it a bit last time because I think when I think of torts right away, I think of negligence when I think about the purpose behind torts, because again, it's the idea that it may not be intentional that the person wanted to harm someone, but their actions or inactions, in fact, did. So if they didn't take away the I'm thinking if they didn't take away the garden hose, right, that we mentioned last time, and someone was injured, that's negligence. If they didn't put up a barrier to prevent someone from falling into the hole next to the driveway and somebody falls in that hole and is injured, that's negligence. So negligence, again, is that reasonable person standard that a jury of your peers may ultimately, if it gets to the jury and gets to the trial level, not just a settlement, will then be a situation where you really have to beware because you'll be held responsible if you're the defendant for your action or inaction because you allowed a situation to exist or even caused it to exist. You didn't fix the light if you're the landlord. And so there was somebody who tripped and fell because there wasn't proper lighting. Well, maybe the landlord didn't do that on purpose, we're going to assume, but that could be negligence because the landlord owed a duty to the tenant and breached that duty by the unreasonable behavior of not having safe lighting or having a broken lock on the door. So there are things that are going to give rise to, again, the civil action for negligence. It's going to be a negligence lawsuit. And we'll look at that. And actually, you're going to spend a lot of time looking at that in the module. So I'll just say that I've already kind of told you the elements of a tort just in a common sense kind of way, but let's just list them out for here, and then you're going to go into more depth throughout this module. So for negligence, there's always some sort of duty, like the duty of the landlord to the tenant, or the duty when you get behind the wheel of the car, the public to drive safely, or the duty of the homeowner to anyone entering the premises or outside the premises to make sure that they maintain a reasonably safe premises. So that duty, then there's something missing, the lack of a safety mechanism or proper lighting that we consider unreasonable. So that's the second element would be that there was a breach of that duty, that it was not reasonable, that the action or inaction took place, and that causes, so there's causation, you're going to see proximate cause is the first kind of causation, and actual cause. So it causes an injury, which is our last element. So you're going to see that those are the elements that it was foreseeable it caused the injury, and it did in fact cause the injury, and we're going to deeply dive into each of those and see how that works. And remember, that's just the plaintiff's case. Then we look and see, well, what defenses does the defendant have? And it's not just one-sided. As I've said throughout the semester, there's two sides, at least two sides to every story. And keep in mind the third side, we have plaintiff, defendant, and then the public. How do we want our citizens to behave? And that's why it's really shaped in, I think, a very reasonable way. And I kind of kid when I say the wacky world of torts, because a lot of people look at it that way, but they haven't looked as deeply as you will see that it really does make sense. And that's why we give the defendant an opportunity to raise defenses and say, well, it wasn't my fault. I shouldn't be held responsible. The plaintiff took too big of a risk. And by doing that voluntarily, was willing to accept the consequences of the injury. That's assumption of risk. So you'll see there's different kinds of defenses. Or it was the plaintiff's own negligence that caused it. That's comparative negligence or contributory negligence. And then that might reduce how much the defendant is responsible for paying at the end when it comes to damages. So those are the elements you're going to see in play in a negligence case as you look in this module this week. And the last thing we're going to look at this week is strict liability, that third category of torts, because in a strict liability case, those are special situations where we, as members of society, have said we're going to hold this person responsible, even though they didn't do it intentionally or negligently. But that person, by virtue of the relationship between the two people or by the activity that that person is undertaking in this business, we are going to make these judgment calls as a society and call that a tort of strict liability and hold that person, in a way, it's like automatically liable. So examples of that, we're going to hold the employer strictly liable for the torts, for the injuries that take place to the employee. That's an example of a strict liability tort. We're going to hold parents responsible for injuries that their children might cause to others. So that's why your parents, when they lend you a car or they give you the car and they say, don't lend it to a friend, because they know they'll be held liable if the friend then drives the car and is injured. So you're going to see things like that. Even if the employer tells a pizza delivery boy, it's the employee, drive safely, but the pizza delivery boy goes out and hits a pedestrian while delivering pizzas, that employer, not just the pizza delivery boy, who might also be responsible for, as we've discussed in this class already, driving and driving in a negligent way, we're going to also, in addition, hold the employer liable for the torts of the employee. And we're doing that not because the employer should have instructed the employee differently, but because we're thinking we're making the right incentive here. So that then, oh boy, if you were going to be held liable as the owner of this business, you're going to be very careful in who you hire and you're going to properly instruct them, but we're not going to require the victim to prove that you didn't do that. It's just automatic strict liability. So those are examples. You'll see others where somebody's got hazardous material and that material, let's say it's chemicals in a truck, leaches out, spills out, and causes damage, causes injury. Well, we're going to hold the owner of those materials responsible. We're not going to dig into, of course, we'll look at the facts, but it's like a strict liability, an automatic kind of liability in those special sorts of situations. So you'll see what those are and where we as a society have had that judgment call that we are going to put it into the category of strict liability of torts. Hopefully it all makes sense to you. And if not, of course, I'm here for any questions, but read through it, work through the material, and especially the hypotheticals to see how the facts fit those situations. And you may be one of those participants in this lawsuit in the future, hopefully not the victim, the injured one, hopefully not the one who caused the injury, because you're going to be so super duper careful in this class, and you're going to, after this class, be very aware of the world around you. I say, that's a tort waiting to happen. And I go and I unplug cords and I make sure there's no tripping hazards. It actually shapes your behavior when you start to look at the world this way in the wacky world of torts. And hopefully that leads to less injury in the future, fewer people injured, and fewer of these situations. And that's what we hope. And if not, at the very least, we're going to compensate those injured and have the person who's responsible do that compensation. So that's where we are with torts. And like I said, you may still be a juror or somewhere else in this process, but you at least have seen it here first, folks, and enjoy, because this stuff is really fun. I like looking through torts and finding these different interesting patterns and what if this had happened instead and what if this happened. So have some fun with it and you'll learn very important, useful information. Take care.